now we're on to our question period. We are like right on time today, which is great. And we're going to be switching now to our questions. It looks like we have 27 questions as of right now. Okay, let's see. The first question is, our association must cross another association's property to access our homes. Let's see here. Let me just see here. Okay, so our association must cross another association property to access our homes, and we're required to pay their annual assessment to use their roads. I requested to ADOT that our entrance gate be moved to where our emergency exit is, but they denied it due to safety and traffic concerns, even after I provided all necessary paperwork. I read Arizona law and wondered if it prevents us from being denied property access, since these are the only two entry points for our association. Can this law help us stop paying the assessment to the other association, which keeps increasing each year? So, great question. A couple thoughts on this. There's probably a written agreement or maybe even a recorded easement that allows your association to use the other association's roads to get to your association. And if I had to guess, the city that you live in that was a requirement for your association to be built. And usually there's a requirement to have two, like an entry and exit for emergency vehicles in order for the development to be allowed to be built. So if I had to guess, this is a requirement that the city has. You probably have a contractual obligation with this other association. And so it's hard for me to comment on it without seeing all the paperwork, looking at the easement, looking at any sort of written agreement there was, for financial responsibility for, using their roads to get to your association. And then also it's likely that that back exit that's part of your association can't be changed into a front exit because of the way your association was set up. But if you want more information on that, you're welcome to reach out to our firm. I'm happy to take a look at it. Okay, next question. Is there any statute of limitations when it comes to a homeowner's violation of the ARC guidelines? For example, if a homeowner planted a tree that was not on the approved list, but years later received a violation notice to remove the tree, does the homeowner have to comply with the notice and remove the tree? Since a substantial period of time has elapsed, does the owner have to comply with the architectural guidelines? So great question. If the trees existed for more than 2 or 3 years, you're really not going to be able to enforce that under the doctrine of waiver or latches. So I think that's kind of a good litmus test. You can check to see how long the tree's been there. You can look at aerial records, Maricopa County tax assessor. Those are listed on that page through a link. But if it's existed for more than 2 or 3 years, you're not going to be able to force that owner to, remove that tree or whatever. Now, if the tree dies and replacing it with something else, that's when you would be able to say, no, you need to follow the ARC guidelines. Okay, next question, number 3. Can you provide some insight on how HOA boards conduct online voting emails to approve an item in between regularly scheduled board meetings and later ratify the decision at the regularly scheduled board meeting? Can you share your thoughts on doing this? So, yes, I can. First, we have a great cheat sheet on the Arizona open meeting law, and this is a really good overview of your requirements under Arizona law, that anytime a quorum of a board is meeting to discuss association business, it really needs to be an open board meeting where the owners are notified 48 hours in advance via posting a notice and the agenda of what's going to be discussed at that meeting. That is the law in Arizona. Now, some associations and some management companies are encouraging associations to vote electronically by using an action by written consent or action by unanimous consent outside of the board meeting to make decisions. And then at the meeting after, the next open board meeting, they ratify that decision. That's a risky thing to do, in my opinion, in light of the fact that the open meeting law is very specific Really, the only time I would be using, email to vote on things outside of a board meeting for a board would be if it's an emergency, a true emergency, where you cannot wait 48 hours to notice a meeting and a decision needs to be taken to protect the association. So I really do not encourage clients ever to make decisions by email outside of a board meeting absent emergency circumstances. There are two cases that have been decided by administrative law judges, which support, my opinion on this, that you shouldn't be doing this unless it's an emergency. Okay, next question, number 4. This is in Arizona. I thought the amount was under $2,000, but I think a law was just recently passed with increasing the amount to a lot more. Is this correct? Can you explain? Okay, so this is regarding foreclosures, and we talked about this at the beginning of the presentation today. So starting September 26th, which is the effective date. Let me still check to make sure I've got that date right. Starting September 26th, yes, Friday, September 26th, there's going to be a whole bunch of new legislation that's going into effect, the 4 things that we talked about at the beginning of the presentation. And if you're a planned community, it's going to be more difficult to foreclose. So what you want to do is look at Senate Bill 1494. If you're a planned community after September 26th, like we said earlier in the presentation, we can't foreclose until the minimum assessment delinquency time period is 18 months past due. And then, or $10,000 is owed. So, that's going to be the law starting September 26th. Okay, question number 5 from an owner. We had to condense this because it was a little bit long. So many homeowners in our community are concerned about poor HOA management, declining property values, and serious maintenance violations. Violations have gone unchecked. Homeowners are divided on assessments, and a high percentage of rental units raises concerns about financing and being able to sell our units. Given these circumstances, what legal and financial risks do homeowners face if the HOA fails to maintain the property and enforce its governing documents? So the risks what legal and financial risks. So legal risks, the homeowners aren't going to be sued, right, for anything, but the association potentially could be sued, and that could have a direct impact on the owners in the association in that, if you have a lot of insurance claims, your premiums are going to go up. So, your assessments may go up. Or if things aren't being maintained over a long period of time and there's a bunch of deferred maintenance, there's going to be special assessments, and every owner is going to have to pay for the special assessment. You may not be able to sell your homes or your units if you live in a condo. So these are all, problems that, potentially will affect you. So not to be a doom and gloomer, let's look for some light at the end of the tunnel here. I really suggest that you consider running for the board or becoming more vocal as a homeowner to try to get positive change in your community. Okay, question number 6. Also, we had to condense this particular question. A rental property regularly violates HOA parking rules by keeping its garage unusable for vehicles. Probably they've got a bunch of stuff in the garage, right? Storage. They fill their driveway and park up to 7 cars on the street, sometimes blocking the fire hydrant. The number of vehicles suggests possible over-occupancy in a 3-bedroom home, raising security and code compliance concerns. Given these circumstances, is the property owner responsible for correcting the tenant's violations? And can the HOA or city enforce limits on parking, occupancy, or safety hazards in rental properties? Well, a couple of things that you can do here. Number 1, you can contact code enforcement for the city that you live in and have them investigate to see if there are any code violations. Second thing that you can do is notify the association of your concerns, and the association can cross-check their documents to see if there are any violations of the documents, the CC&Rs, bylaws, rules of the association. And if there are, they can contact the landlord owner regarding the violations, potentially fine the landlord owner, and maybe even file a lawsuit if that's something that's economically feasible and a good idea. So you do have different, options here. We have a great cheat sheet on how to work with rental properties that I would encourage you to take a look at. You can find that on our website at mulcahylawfirm.com, or we're going to be sharing it with you right here in this presentation. Okay, question number 7. How would we go about changing our HOA president? Okay, looks like you're not happy with the current officer president of your association. So look at your bylaws. Typically, in most bylaws, a majority of the board can remove an officer from their officer title. So, but it wouldn't remove the director from. So when you're president of the association, maybe you're president and then you're also a director at large for the association. So you can strip them of their title by a majority vote of the board, but you can't remove that person from the board altogether without following the procedures under state law, which, require like a petition, a special meeting of the membership, and a certain percentage of the owners to remove that director at large from office. So short answer, you can, as a board, a majority of your board can, remove the president's title, remove them from that position and appoint somebody else. But that person will still be director at large on the board. Okay, next question. Can you talk a little bit about grandfathering? Is it a good idea or a bad idea? I'm not sure what context that you're raising grandfathering in, but if I had to guess, maybe you're talking about grandfathering as part of amendments to an association's documents. If that's the case, we have a great cheat sheet called Amending CC&Rs. It's a 5-step plan. And if that is the case, you may want to take a look at that. So whenever we're doing an amendment, especially in light of the Holloway case, we're definitely thinking about, do we want to grandfather existing owners so that we don't, have a legal problem under the Holloway case, changing the use of a property without 100% approval of the members. And so what is grandfathering? Grandfathering means, like, let's say that we're going to pass a rental restriction in your community. Your CC&Rs do not have anything regarding rentals. So under Arizona law, an owner would be allowed to rent their property. So let's say we want to put a minimum 30-day rental period on, renting in your community. Under the Holloway case, it's our firm's opinion that if you currently have, availability and you're allowed to rent according to the way that your documents are written, that would be a change of use and you would need 100% approval of the members. Now, a crafty way to get around that would be to grandfather all existing owners in the amendment. So the language should say this amendment only applies to future owners that purchase after this amendment is recorded. So we would get around the Holloway ruling, which would require 100% approval for a change of use because something isn't foreseeable. And so basically what would happen in that case is that any new owner who's buying would know it'd be foreseeable to them that, hey, this provision exists, and it would, be legal under the Condo case. And all the existing owners who are owners, at the time the amendment is recorded, they would all be grandfathered and would still be able to have no restrictions on their leasing if they chose to lease their property in the association. So is it a good idea or a bad idea? I mean, it's a tool to move forward with progress in your association and to limit your liability. So, yes, we do use it pretty frequently. Okay, question number 9. Our master association will not share violation notices with our sub-association's homeowners. They say the violation notices are confidential. Is this accurate? This goes to the records request laws in Arizona for condominiums and home communities. So any book and record of the association, is generally speaking should be available for an owner to review after they make written requests to the board. There are some exceptions to that, like if it's a legal matter or advice from legal counsel, it's personal health or financial information about an owner. A violation letter could potentially fall under the personal health or financial. It could potentially fall under litigation for the association. So I don't know that much about the situation where I can, really weigh in on this. What we typically will share will be like a violation list without names and with redacting the addresses. That way we're not sharing any personal information. Maybe that's an option that you can do to see if you can request it, doing it that way so there wouldn't be any personal information shared. Okay, may a board refuse to record open meetings is question number 10. So yes, if your board doesn't want to record open meetings, you don't have to. It's not required under the law. The new legislation that's going into effect September 26th just talks about if you record, you have to keep it for 6 months and then give it to the owners. If they request to see an unedited version of it, you have to provide it. But you're not required to record open board meetings. You are required to take meeting minutes of every open board meeting and every executive session meeting. Okay, question number 11. There are no restrictions in the CC&Rs concerning committee membership. Can or should the community manager be the second member of a 2-person governing documents committee? I guess can or should, why would they be? Would be kind of what I'm thinking. Usually the manager is just there to, be at the will of the board. I typically do not see any managers in 29 years, almost 29 years practicing law, where the manager is that involved in a document amendment provision, a document amendment committee. I think it would be better to have homeowners, homeowners or even better board members, to be on the governing documents committee. Number 12, what are the pros and cons of using a professional debt collection agency that can report to credit reporting agencies for homeowners with long-term debt to the association? Our management company has been unsuccessful in collecting a debt. Okay, the pros would be that they're probably going to do it at no charge. The cons are that these professional debt collection agencies will send 1 or 2 letters and then they give up. So they're only looking for the fruit that's ripe and ready to drop. So people who are ready to pay, they're not going to, be making any extra effort to, go after the hard people to collect from. They're looking for easy money fast, in my experience. If they are reporting to credit agencies for homeowners, it could be a liability for the association because if the debt's paid and the credit company isn't notified, we could be sued under the Fair Credit Reporting Act. The association could be sued. So I really think the better approach here truly would be instead of handing it over to a debt collection agency, would be to just make a decision. Is this debt collectible? And the best way to do that, like our firm regularly looks at files for associations and we will say to them, okay, here's the credit snapshot of this person. They're a former owner, they're in bankruptcy, they've got a ton of debt. This is probably somebody that we're never going to be able to collect from. Maybe we record the judgment, and when the judgment is up for renewal after 10 years after it's, been decided or issued by the court, then we reevaluate the credit then. But right now, this person does not have good credit, and maybe we do, maybe we don't renew the judgment at the end of the 10-year period based upon the credit. I think having somebody who understands collections and who can quickly look at a file and say, this person's uncollectible, or this person I think is collectible and why, is, a really good decision. You may want to once you make the decision, then maybe send it to the collection agency, but be careful on that Fair Credit Reporting Act. If they're reporting to credit reporting companies, you want to make sure that whatever they're reporting is accurate. Okay, next question, number 13. Can a board member file the ACC report, so the Arizona Corporation Commission report? So short answer on that would be yes, but the board member is going to have to ask, there's certain questions at the end of the ACC report that have to be answered by all board members. And so they need to poll the board members, so that they can adequately and properly fill that ACC report out. But yes, board member can do it, the manager can do it, your attorney can do it for you, as long as all board members are consulted and answer the questions that are required to be answered on that report. Okay, question number, and remember that ACC annual report needs to be filed once a year. So you should have that on your radar, that is, something that your board needs to do every year so that you keep your corporate status in place, because that corporate status is a shield around the corporation so that the individual owners can't be personally sued. So you always want to keep that shield in place. And the way to do that is to file that ACC report every year. Now, every association has a different due date. So you should go to the Arizona Corporation Commission website and look up when your association's annual report is due. And they have a little email reminder system that you can put your email address in so that you are notified when the annual report is due each year prior to it being due each year. Okay, next question. Let's see. Our bylaws state, number 14, our bylaws state that the president shall be ex officio chairman of the board. They also state that in the absence or inability of the president, the vice president shall have and exercise all authority of the president. Our bylaws do not make a provision for who should chair the board meeting if both the vice president and the president are absent. If we have a quorum with enough of the board members attending, can we still hold the board meeting? So short answer on that would be yes. Quorum of the board, you can still make decisions. And then whoever's there, the quorum, you just decide among yourselves who's going to act as the chair for that meeting and make sure meeting minutes are taken. Now, I want to just mention one thing. Don't be sneaking around and doing board meetings without, the president and the vice president, because you don't want them there. Every board member should be provided notice of the meetings, and all owners, obviously, should be provided notice under the law 48 hours in advance of the meeting. Okay, next question, number 15. If you share the screen to show a picture during a Zoom meeting, does that screenshot have to be captured as part of the recorded meeting? Well, it should be captured. So I'm wondering if it's not, if you share the screen, it should be with the recording. So it should be part of the Zoom meeting. I guess, does it have to be in the minutes? Probably not. If it was discussed, probably not. It would be best practices to include it with the meeting minutes. But I don't think there's a requirement to do that. Okay, number 16, is it necessary to amend the CC&Rs to validate the use of Zoom for our board meetings? So short answer on that would be no. Number 17, could you go over the new declarant law regarding turnover? I'm not sure what law you're talking about. I think maybe you're talking about the legislation that went into effect last year. And if you go to our website and go to our cheat sheet page, you can look at our update from 2024 legislative session, and it will talk a little bit about the different requirements for turning over association control from declarant control to homeowner control. Question number 18 from a treasurer. My board wants to make an exception to our CC&Rs. Specifically, they are going to allow one unit to park a utility trailer in the community parking area for the winter. Our CC&Rs state one unit, our CC&Rs state no longer than 48 hours can a utility trailer be parked. Is the board allowed to make this sort of an exception without a membership vote or change to the CC&Rs? We have 3 board members. All 3 were appointed and not elected. 2 want to allow this exception. 1 does not. I mean, if it's in your CC&Rs that, this shouldn't be allowed for longer than 48 hours, I don't think that this is an exception your board should make, because you're contractually obligated to, enforce your CC&Rs. Okay, next question, 19. I realize that a board member does not have to sign a code of conduct. And have you seen this, and how do you handle? As you might expect, this board member is very antagonistic on everything. Conversation with the board member has not been accepted or approved. Okay, so we have a cheat sheet on code of conduct on our website. Just go to mulcahylawfirm.com and you will see the code of conduct cheat sheet there on our cheat sheet drop down on the homepage. So we get into situations with the code of conduct, typically when there's bad behavior on a board, or people aren't getting along with the board, or we can't get anything done on the board. And so we bring out the code of conduct, and basically it just reminds everybody these are your obligations to the corporation. And, you have a duty of care, duty of confidentiality, duty to avoid self-dealing. And we ask that the board members sign it. But of course, what typically happens when we bring that out, the board member that is the biggest problem refuses to sign it. So in those circumstances, what we do is we just have a majority of the board adopt it. And, we don't have people signing it. We just have a majority of the board, make a motion to adopt this for the board. And, does it really add anything extra? Probably not. It's just a good reminder to all board members, that you should be adhering to your fiduciary responsibilities to the corporation, upholding the CC&Rs, and again, having proper duty of care, keeping things confidential, and also avoiding self-dealing as a board member. So best way to handle it, I think, is have a majority of the board approve it if not everybody on the board will agree to sign it. And also then, if this person starts to violate it, then have your attorney write the board member a letter outlining what their deficiencies are and why they are, not adhering to the code of conduct that is expected and required for board members. Okay, question number 20. I'm just going to do a quick check to see how many total questions we have. Looks like we're up to 32 questions. So we have a homeowner who about 4 years ago put a massive 4-foot cross in his front yard. And as an HOA, we've given up because fighting him was starting to drain us financially in legal fees. The city hasn't been any help, as they say there is no precedent. This house also puts very strong religious script on their car's sunshade and then backs the car into the driveway. The house next door is trying to sell, but per their real estate agent, potential buyers are not even entertaining showing once they see the religious stuff they would be living next to. The seller has reached out to the board for help. Any ideas or thoughts? Well, it looks like this violation has existed for 4 years, and so it may be very difficult to enforce this. There may be some fair housing issues, that might not, we might not be able to manage that because it could be a violation of the Fair Housing Act. So I do think your association's really in a pickle on the situation. Based upon the amount of time that's lapsed, and there probably isn't too much that the board can do about it at this point. Okay, question 21. What is the typical order of process before sending a homeowner to the attorney or involving the attorney, and should a homeowner know up front what the attorney's legal fees will be? So there is a law that requires that prior to a matter being turned over to the association's attorney, that, like for unpaid assessments, that the association write a letter to the homeowner and say, hey, your file is going to be turned over to the attorney if you don't, pay this debt now. So there is that law that's out there. So, typically what will happen in an association is, whether it's a violation or assessment collection matter, the association board or the management company will write a letter or two, and then it gets turned over to the attorney. And no, the homeowner typically will not know up front, meaning we don't send a fee schedule to the homeowner, but if we're collecting money from the owner, we will include a breakdown of what the amounts owed are, and that will include how much the attorney's fees are to date for that particular owner. Question 22. How much D&O insurance do you recommend an HOA board carry? Our board has $5 million in coverage. I would say, I don't know how large your association, but that, is typically on the higher end. And so it's probably okay. You might want to talk to your insurance agent and discuss whether or not that's adequate coverage for your association. But it looks good from my perspective. That's in the higher range that we see for associations. Okay, 23. Should an HOA have an additional insurance policy for workers' comp for its board and committee members and crime insurances, or are these both covered under the property liability policy? So I don't think that the workers' comp would apply to the board and committee members because they're not being paid to serve or to work for the association. Crime insurance, I'm guessing that you're talking about like cybersecurity, which a lot of associations are getting now. So that's something that you can talk about with your agent. Is it included in your current policy, or is that a separate policy? Question number 24. How can you make the member or owner responsible for the deductible if they were the cause of the damage or claim? Well, you have to look at insurance claims on a case-by-case basis. But if the owner, has a grease fire and they, burn down their unit, there is going to be, of course, the association's policy is typically going to be the primary, and the homeowner's insurance policy is going to be secondary. But, typically if the root cause, whoever's the root cause of the problem, in this case, the grease fire, is going to be responsible for the deductible. And like I said earlier in the presentation, the deductible is just deducted from whatever the total amount of money is given by the insurance company, to the association under the policy to pay for repairing the damage. So how can you do it? It's really the board just notifies the owner that this is how this is going to be handled. Okay, question 25. In my condo association, the HOA is responsible for roofs and skylights. Recently, the HOA replaced the skylights, but some are already failing. One owner has reported her cracked, leaking skylight 3 times over 6 months during a recent storm. Water damaged her ceiling drywall. Property management told her it's her responsibility to fix the drywall, but she feels the HOA should pay since she reported the issue and the skylights were poorly installed by the HOA's chosen contractor. How can she get the HOA to cover the drywall repairs caused by water damage from the faulty skylight installation? It does sound like, this is a situation where the HOA would be responsible. So I would write a letter I'd have this owner write a letter to the board, and, if they fail to act, they may have to get an attorney to write a letter to the association. I don't think this is something that would be covered by insurance, but they're going to have to, contact the board to get this paid. And if they refuse to pay it, then you may have to get legal involved, your individual lawyer involved to help the owner, send a letter to the association board. Okay, question number 26. In our condo association, we had a per unit water deductible. A couple of months ago, we started having lenders require a special endorsement to our property policy with a max deductible clause that overrides the per unit water deductible. This additional endorsement is expensive, and many owners were upset with the board for adding an additional premium. At the time, 2 lenders would not fund if the endorsement wasn't added. Is this becoming more common of a requirement from lenders on conventional loans and others? We're really not seeing this on a regular basis, so it's not common in my experience. Question 27. We are in Sun City, and our condos are essentially duplexes with open common area in the back, and there's no way to control who walks on our property. Do we need to put up signs that say private property and cite any ARS legislation? You certainly could do that if you want to. There's no legal requirement to do that, but if you're seeing a lot of trespassing, that might be a good thing to do. Okay, question number 28. Even though we have a bare walls insurance policy, an owner thinks the HOA should pay for the water damage caused by a broken pipe in her bathroom wall because her homeowner's agent told her it's the HOA's responsibility. What is the best way to handle this situation to avoid bad feelings among owners? Okay, so bare walls policy means that, anything from the paint in is going to be the owner's responsibility, and anything, from the wall, into the, airspace, anything that's not in the airspace of the owner is going to be the association's responsibility. So I don't know. It says a broken pipe in her bathroom wall. I don't know enough about that bathroom wall. Like, is it common area, or is it, a wall that's within the airspace of her unit? In a condo, typically the walls, it depends on where the broken part of the pipe is too. Is it inside the airspace of her unit? So there's a lot of questions here that I can't answer this unless I know, more information on this. A good way to handle disputes like this is just take it right to your agent and talk about it with the agent, and then go back to the owner in terms of whether this is covered or not covered. And also, you may want to bring in your legal counsel to weigh in on it as well. After looking at your association's documents and then looking at the root cause, they might be able to give you a better, interpretation as to whether or not this is insurance coverage for the association or the owner. Question number 29. We do not have direct employees in our HOA. but we have numerous volunteers doing work. Do we need workman's comp insurance for volunteers? That's a really good question. I mean, they're not being paid, they're just volunteers. But the thing that worries me is what if they get injured volunteering? So you really want to be mindful of, I had an association once many years ago that was having volunteers jackhammer out the pool decking at the pool. That is totally not a good idea. That is dangerous. You should have somebody who's licensed and bond to doing that, not volunteers. So I guess, are you wondering, I have volunteers that attend board meetings. Do we need, workers' comp for that? No. I would really shy away from using volunteers to do anything that you should be using licensed and bonded contractors for. If a volunteer is changing a light bulb, and they get injured, yes, they may have a claim against the association. The way to avoid having workers' comp insurance, which would be really very unusual for volunteers, is just don't have volunteers doing anything, that is really something that should be done by a vendor. Okay, next question, number 30 from Facebook. We just received a violation notice from the HOA 2 days ago. Last week, we put in an architectural request for some landscaping changes. At the board meeting last night, they announced that they would review the architectural request. They would not review the architectural request because we were not in good standing. There's nothing in our community docs that says they can do that. Okay, so if you put in an architectural request and there's nothing in your documents that says that, hey, architectural requests aren't reviewed if you're not in good standing or you own the association, then yes, the board is not acting appropriately. I don't think I've ever seen a provision in 29 years, almost 29 years, where, somebody cannot submit an architectural request because they have a violation on their lot or because, they owe money to the association. So I think you need to push back on that and just say, show me in the documents where it says you can do that. And I've talked to an attorney, and that attorney's opinion was that you don't have the right to do that. Okay, question number 31, also from Facebook. You mentioned executive meeting minutes need to be done, but are those available or should they be available for homeowners to view? So no, executive session meeting minutes are only available to the board to view. So homeowners cannot make a request to see executive session meeting minutes. Question 32, what's your opinion on adding a one-time fee to a new sale, to new home sales that would be directly paid to reserve funding and can lower the fee of some of the same kind to be applied to rentals? Is there a limit on this fee applicable to new home sales and rentals? Okay, a couple thoughts on this. So you got a lot going on with this question. So yes, my opinion on this is that I think it's a favorable thing to have, we call it a capital contribution fee or a transfer fee. We have a cheat sheet on this topic. It's called transfer fees versus disclosure fees. There's very specific requirements in order to charge a transfer fee under Arizona law. So you have to meet all those requirements. Like it has to be in the CC&Rs. It has to touch and concern the land. It has to be, directly given to the association. And so there are very specific requirements for that transfer or capital contribution fee. And I'm in favor of it. I think it's a good way to fund your reserves. Now you're talking about another fee for rentals. There's under Arizona law, there shouldn't be any fee other than, there's a $25 fee that you can charge, when there's a change in occupancy and the owner has to provide certain categories of information, and we can charge a $25 fee for that. I don't know how much your association is charging for rentals, but there is a limit on that under Arizona law that your association needs to be mindful of. Okay, question 33. I may have skipped this question. I'm sorry if I did. My board wants to make an exception to our CC&Rs. Oops, I haven't answered this. So I did answer on this already about the trailer. And I said that you cannot make an exception if your CC&Rs do not allow that type of trailer parking. Okay, question number 33. Now that we see homeowners installing commercial holiday type lighting permanently, they can activate the lights year round with pulsating or moving lights. We have a holiday lighting rule when Xmas lights must be on and turned off. Now, should we write an additional policy? Sounds like you may need to do that if they're keeping them up year round and they're activating them for different holidays like 4th of July or whatever. Okay, last question for today, number 34. Our longtime lawyer that management company has used for advice is now retiring. If the board and management company hire a new lawyer, should this be brought to the attention of the membership? Also, the previous attorney would offer advice and the secretary or management would paraphrase the advice. I believe that advice without attorney letterhead is hearsay. Am I correct? Okay, lots going on in this question. So be careful, like you said, longtime lawyer that the management company uses. You don't ever want to hire a lawyer that is like the management company's, that works for the management company, in my opinion, or that the management company is forcing you to use. And why is that? It's because, who are they going to be loyal to if there's a dispute between the management company and your association, right? You want an independent person who's always going to be your lawyer and have your best interests at heart. Our firm never represents management companies, and we are, not like the go-to person for any one management company. We work with everybody in the Valley. And, we work with everyone in the Valley by our clients. So, of course, we get along with the management companies because we're requesting ledgers and we're asking for photos of things that they may have. But I am, not being fed work by any management company. My client is the association. Okay, so lawyers retiring. Should this be brought to the attention of the membership if the board's hiring a new attorney? Really, you don't have to tell the membership this, but what you should do is vote on it at an open board meeting and have the minutes reflect it. Paraphrasing the advice of an attorney is never a good idea. I think it's prudent to always get something in writing from the attorney, whether it's an email or a formal opinion letter, so that everybody can see what question was asked and what the answer was. Today, we had over 180 viewers at our peak during the seminar today. So that's amazing, really good turnout for our class today. We have one in-person Scottsdale class coming up this month that I want to just make sure that we let you know about. The city of Scottsdale is doing in-person classes right now. And I'm going to be teaching a class on Thursday, September 18th, in person, between 1 and 3 o'clock. You're, of course, welcome to attend. And it's at Mustang Library. You can find out more information on it on our website. We're going to be talking in depth about the 2025 legislative update and how to effectively work with your community manager and your management company. And again, that's an in-person class that I'll be teaching between 1 and 3 o'clock this Thursday at Scottsdale Mustang Library. We also have another in-person class that we're going to be teaching for Scottsdale on Wednesday, October 8th, between 1 and 3 p.m., again at Mustang Library. And this is going to be practical strategies for aging HOAs and condominiums. Like, where do we go from here? Our association has deferred maintenance. We are looking at a big special assessment. We've got a lot of capital improvement projects we need to do. We're going to be giving advice on aging associations. How do we get back to, having things maintained, and how do we turn this around, basically? Okay. Also, there is going to be our First Fridays. Don't forget about that. Can't believe it's already September of 2025, but our next First Friday is going to be on Friday, October 3rd, between 9 and 10 a.m. First Fridays is your chance to ask one question at no charge, and we answer the questions in rapid fire. You can find out more information on that on our website, where we're going to be sharing information with you now. And then last but not least, we have our October class, which is class number 10 for the Neighborhood Services HOA Academy. We teach that on Zoom and Facebook Live starting at 11 a.m. It's always the third Tuesday of every month. And we're going to be talking about assessments, how to get people to pay assessments, and large capital improvement projects. So that'll be a great class on virtual class on October 21st. So thanks so much, everybody, for being here today for our class. We look forward to seeing you at future classes, and we appreciate you caring about your association and wanting to make it better. So have a great rest of the week, and see you soon.